Okay, so next we have a pre-recorded presentation for you by Dunstan Farrell, also an equality-related presentation on the law's baby steps towards equality. Dunstan is one of those doyens of employment law in the country, if I can put it that way. He's been practicing as an attorney for 38 years, specializing in the field of employment law for 25 of those 38 years. He served his articles with Denise Rates and later joined Shepston and Wiley in the employment law department before he eventually started Farrell and Associates in March 2003 as a boutique employment and labor law firm. His wide-ranging experience includes advising, consulting, and representing national and provincial employers in all forms of employment law and litigation, and this has ensured that Farrell Inc. is regarded as a leading firm in the employment law field. So over to Dunstan.
I'm speaking from Durban, Dunstan Farrell here, Farrell Inc. Attorneys. I'm talking today about the amendments to the Basic Conditions of Employment Act dealing with parental leave in general, parental leave, father's leave, adoptive parents leave, and commissioning parents leave. The title of my talk is The Law's Baby Steps Towards Equality. I don't know who thought of that title. It certainly wasn't me. Anyhow, what has happened, and these amendments were introduced in 2018 and passed into law in this year, 2020. Why these changes, one might ask? Well, it is bringing, and I'll discuss in a little bit of detail, briefly, some international law, the Dutch and the Canadian law, but it's bringing South Africa in line with international standards, and maybe we're there or we may not be there, addressing some of the imbalances of the past, more particularly apartheid issues. A lot of South African families are single-parent families because of the evils of apartheid, parents or fathers particularly not being at home. So these amendments will some way address those evils of the past. So where to from here? The law was signed by the President, Cyril Ramaphosa, to come into effect in January of this year. And it was passed on the 27th of November, 2018. Prior to these amendments, we had maternity benefits for moms only, and these are quite significant changes addressing all sorts of constitutional issues to bring us in line, as I said earlier, with international standards, and to make sure that we comply with the scope and the parameters of the Constitution. I want to move on now briefly to talk about parental leave. And parental leave is section 25 capital A of the amendment. An employee who is a parent of a child is entitled to at least 10 consecutive days of parental leave. So that's the leave entitlement. An employee may commence the parental leave on the day that the employee's child is born, or a date that the adoption order is granted, or that the child is placed in the care of a prospective adoptive parent by a competent court, pending the finalization of an adoption order in respect of that child, whichever date occurs first. An employee must notify an employer in writing, unless the employee is unable to do so, of the date on which the employee intends to commence parental leave and B, return to work after parental leave. Notification in terms of this section, subsection 3, must be given at least 1 month before the employee's child is expected to be born, or the date referred to in subsection 2B, namely when the adoption order is granted or the child is placed in the care of the prospective adoptive parents. The payment for parental benefits will be determined by the minister. The next section is the introduction of section 25B, That is the section that deals with section 25B, which deals with adoption leave. Adoption leave: an employee who is an adoptive parent of a child who is below the age of 2 is subject to subsection 6, entitled to adoption leave of at least 10 days consecutively, or B, parental leave referred to in section 25A, namely the paternal leave that we've already spoken about. Section 2 of 25B, an employee may commence adoption leave on the date that the adoption order is granted, or that the child is placed in the care of a prospective adoptive parent by a competent court pending the finalization of an adoption order in respect of that child, whichever event occurs first. I just want to, we spoke briefly about the law of the Netherlands and Canada. So in the Netherlands, employees with children aged up to 8 years can take unpaid parental leave. The leave is unpaid unless agreed otherwise in a collective agreement, or they are eligible for such leave as soon as they start working. In the sense, if a partner or an employee gives birth, the employee is entitled to 1 week of partner or paternity leave following the birth, and this leave can be taken at any time in the first 4 weeks of the birth of the child. What is interesting is that during the first 4 weeks of the birth of the child, one must continue to pay 100% of the employee's salary. Canadian law is slightly different. The eligibility for parental leave of one parent is determined separately from the eligibility of the other. It depends on whether the employee has or will have actual care or custody of the child, and whether proper notice was given to the employer. Adoption is not a novel concept and is not an unfamiliar concept, and an adoptive parent with a child below the age of 2 will now be entitled to adoption leave of at least 10 consecutive weeks, or the parental leave referred to in section 25, capital A. Adoption leave commences on the date that the adoption order is granted, or the date on which the child is placed under the care of the prospective adoptive parents. In terms of section 25A, the notice must be given 1 month prior to the date the adoption order is granted, or the date on which the child is placed in the care of the prospective adoptive parent. If the adoption is made in respect of 2 adoptive parents, one of the parents may apply for adoption leave, and the other parent may apply for the parental leave in terms of section 25A. The choice of leave is determined by the 2 adoptive parents. And then we move on to deal with commissioning parental leave, and this deals with the issue of surrogacy. And this was the addition of section 25C. And surrogacy is not necessarily an issue between same-sex couples or couples who cannot have children, but has now become an elective for some families who choose to go the surrogacy route. A commissioning parent in a surrogate motherhood agreement is entitled to commissioning parental leave of at least 10 consecutive weeks, or the parental leave referred to in section 25A. The commissioning parental leave commences on the date the child is born. The same requirement of written notice is applicable with parental leave. The commissioning parent means a person who enters into a surrogate motherhood agreement with a surrogate mother. A surrogate mother means an adult woman who enters into a surrogate motherhood agreement with a commissioning parent. And a surrogate motherhood agreement means an agreement between a surrogate mother and a commissioning parent in which it is agreed that the surrogate mother will be artificially fertilized for the purpose of bearing a child for the commissioning parent, and in which the surrogate mother undertakes to hand over such a child to the commissioning parent upon its birth or within a reasonable time thereafter, with the intention that the child concerned becomes a legitimate child of the commissioning parent. The leave commences on the date the child is born. If there are two commissioning parents, question mark. There are still many gaps in the legislation and much more to be done. In Canada, the option is given to parental leave, and special leave can start between the birth and up to 52 weeks after, which this is not the case in South Africa. In respect of maternity leave, we have 4 months, but paternity leave is not the same, and it is suggested that paternity leave should be granted up to 5 months and should be eligible to start between the week of the birth of the child and up to one year thereafter. What about guardians and how many children, and about the legacies of apartheid? Those issues have not been addressed in the amendments. In countries that have adopted paternal leave for fathers, studies have shown that both parents are more likely to do their fair share of caregiving that promotes gender equality. This also assists in dismantling the long-standing stereotypes of gender roles in parenting. Fathers who take paternity leave to assist newborn mothers help them recover quickly and reduces the physical stress of birth and the high prevalence of post-traumatic stress disorders that a lot of mothers suffer after giving birth. Paternity leave also allows for fathers to not only bond with their newborn child, but with the mother as well and the family in its entirety, as the father's role is equally important. Child development research also provides that a child bonds with adults that provide for their basic survival needs. In addition to the above, research conducted by the Human Sciences Research Council and the South African Institute of Race Relations found that 60% of South African children have absent fathers, as I've said before, largely a legacy of apartheid. In light of this, the introduction of parental leave will promote the involvement of fathers being present at the inception and the importance of the child having both parents living with them. I trust that this has been of interest and use to all of you, and I thank you for your time. I'm sorry it was not more exciting and not littered with amusing anecdotes and stories, but thank you very much for your time.
It's Dunstan online now to answer some questions live. So if any of you have questions, and hopefully you can try and derive some benefit from his talk by speaking to him live now, to the extent that you couldn't make much out from what he was saying. So if you just give us a minute to try and link to him. Sorry about the technological difficulties. I do think that we are going to get Dunstan online now to answer some questions live. So if any of you have questions, then hopefully you can try and derive some benefit from his talk by speaking to him live now, to the extent that you couldn't make much out from what he was saying. So if you just give us a minute to try and link to him. Dunstan, I can't see him, but Dunstan, can you put your video and your sound on? Because I think you're on mute and we can't see you. Does anyone in the room have any questions, just so that we can assess? Maybe it's just going to be best to suggest that if anyone who is a virtual attendee does have questions, they can stream them online and Dunstan can address them later, because it seems we'll have difficulty trying to get him now.
Why is this also delayed? Hi, sorry, we are trying to connect, but we can't hear anything from, or it's a delayed response from your side.
Okay, please, can you...
Sorry, we are trying to connect, but we can't hear anything from, or it's a delayed response from your side.
Are you able to hear now?
Yes, yes. So if there are any questions, we're happy to take them and Dunstan will answer them. He was just, I don't know if you heard what I said earlier, he was just held up in a meeting.
Okay, so I think the best way forward is then for anyone that's got any questions to please just send them through and Dunstan will answer them later.
Yes, perfect.
Thank you so much.
Thank you.
When the technology works, it's great, and when it doesn't, it's awful.
So, sorry, are the questions going to be sent on the chat or on the app?
I think they'll be sent on the app.
Okay, perfect. Thank you so much.